Sir, you are Andrew Aaron Cecil, correct?
Yes, sir.
Mr. Cecil, have you had an opportunity to read and review your pre-sentence report?
Yes.
And have you had an opportunity to discuss that report with Mr. Lyons?
Yes.
Are you satisfied with Mr. Lyons and the advice that he's given you?
Yes.
Do you wish to explain or challenge the accuracy or the relevancy of any information that is in the pre-sentence report?
Yeah, we had a few things that we want to go over.
Okay.
May I, Your Honor?
Go ahead.
And I have discussed these with the people as well, Your Honor. I want to bring the court's attention to 2 of 12, page 13, the guidelines. There is a simple possession of any controlled substance from 2011 in West Virginia. It notes that the prosecutor did not authorize the, and I think this was addressed, Your Honor, at the GBA sentencing. My clients never stepped foot in the state of West Virginia. Respectfully asked to this be stricken from the PSIR.
Your Honor, Mr. Lyons is correct. We did address this at the other sentencing, and I don't have any information or knowledge of this, so I have no objection to striking number 2 of 12.
All right, so we'll strike item 2 of 12 on page 13 of the pre-sentence report.
Thank you, Your Honor. With regard to, if I may take the court's attention, probably, Your Honor, in my haste to get here, I left my glasses in my car. So I'm moving a little slow, begging the court's forgiveness. There's a reference that my client had never attended college, Your Honor. This is not true. He's presently attending Jackson College. He also completed the Career Food Services program at DOC, as well as not 1 but 2 anger management certificates he has received, and he has the those things for perusal if they would like to see that. Also on page 2, when the recommendation and narrative, it states that he was convicted of assault with intent to murder, which simply is not true. As the court knows, he was convicted and sentenced by this court for assault with intent to do great bodily harm less than the crime of murder. And that would be recommendation and narrative on page 2, just beneath the compass chart in paragraph 1, sentences 2 and 3.
Your Honor, I would agree that Mr. Cecil was convicted of assault with intent to commit great bodily harm less than murder for that offense. And if we are going to add those certificates, do you have those, Mr. Lyons?
I do. Do you have those with me?
So that correction on page 2 with respect to the reference to assault with intent to murder should be changed to assault with intent to do great bodily harm less than murder.
Yes.
Okay, I believe the reference to no college or advanced degree information found for the defendant is on page 21.
Yes, Your Honor.
Under education.
For the record, I share with counsel Michigan Department of Education certificate, Mr. Cecil, for the violence prevention program, as well as his educational program, vocational plan, attending Jackson College at the present, Your Honor. People's perusal.
Can I have your glasses? I mean, are these college courses or just programs?
The vocational is at the college courses at Jackson College. They come to the college once a week and they attend class.
Your Honor, I would acknowledge that I've reviewed those documents.
I guess I'm gonna need copies, I guess.
Not a problem. Mayor Pro, the court may peruse them.
Okay, so I do have a Michigan Department of Corrections certificate of completion relative to a violence prevention program, moderate intensity. I also have an educational program plan, vocational, which sets forth appears to set forth educational program in which Mr. Cecil is participating at the moment. He wants to make copies of it.
Yes, sir. May I? Thank you, Judge. You still to give those to the court, so the court may. Your Honor, may I also keep the court to page 3 of the Presentence investigation report, down to paragraph 1, 2, 3, 4, 5, 6, 7, 8, where they make reference that all the children were present at the home when the GBH occurred. Actually, Your Honor, that simply is not true. I mean, the people assert that the 1-year-old was there. We assert that none of them were there, but I think we agree that they all were not there.
Your Honor, again, this was addressed for a number of victims during that sentencing hearing. And the 1-year-old child, as well as Ms. White, people were both present at the time of the stabbing.
So that was on page 8.
Page 3.
Page 2, down to paragraph 8.
Okay.
Sorry about that.
I can change it to 1 minor child.
Okay, so that should be changed into one letter. So 3. Give or take.
And I take the court back to the face sheet, and again, forgive me, Your Honor, but it has 783 days time to counsel acknowledges receipt of the originals of the form given to the court for perusal. And I return those to my client. Page with the face sheet of the PSIR, 783 days, which is a little more than, as the court knows, 2 years. That the remaining days should be transferred to the actual count 1 manslaughter.
Ms. Wise in response to that.
I think he serves the felony firearm first.
Yes.
Right, but
So
you're,
the credit
so the
goes
math.
on that.
But what we're saying that the credit on that is more than 2 years.
Oh, then he just gets 2 years done.
Right, and the rest goes on manslaughter.
If,
But it doesn't reflect that on the face sheet. I'm sure that's what they're going to do, but the face sheet does not reflect that. He's been jailed.
Right, well, there are still open issues with respect to consecutive sentencing.
With regard to the time he's doing now, but not with regard to the firearm and the manslaughter.
Well, with regard to whether the felony firearm is consecutive to the time it's doing now.
Yes. that falls within the court's discretion.
So that would obviously impact the credit for time served on the felony firearm.
It would.
And so that, I think, is something that will need to be sorted out. Once the court has decided on a sentence.
Thank you.
The last thing, Your Honor, and I believe the people are going to delve into this a bit more than I, but at the plea, there was absolutely no testimony elicited that connected my client to any gang membership, nor to any gang affiliation. Court people, we all had the opportunity to make that record. I can't speak for trials that took place with co-defendants when I wasn't present, Your Honor. But if we're going to be asking for consideration, for the court to consider that, there needs to be a record in the context of the plea that supports that. And at this point, the record is naked with regard to any gang affiliation, Your Honor.
Your Honor, that, oh, I'm sorry.
Let me just make sure I understand your position. Your position is that I can only look at what was discussed during the plea?
Your Honor, and here lies the rub when it's a retrial. There was a mistrial in his initial trial, if I'm correct.
That's right.
I come in here, there's been no testimony, no offer of proof, no record made that he was affiliated with gangs, Your Honor. And the felony charge that had been in place with regard to gang membership was not prosecuted as a result of him tendering the plea that he did. So what we're going to come back now and say, oh, by the way, we're going to still hold you responsible. I don't personally, Judge, I don't think that John Hunts. It is probably within the court's discretion, but I would ask that if the people want to do that, they need to make a record at a separate hearing.
So are you referring to a score on the guidelines or a portion of
Again,
the PSI that you want stricken?
I had my glasses, Ron. I'll just show it to you there.
It's page 19, and page 19 indicates there's no gang involvement. However, he's anticipating my argument to add that information.
Yes.
Yes.
And our argument, Your Honor, is that without that, the record that brings us here today does not support that consideration by the court.
All right. Is that everything then from your side?
I believe that is it, Mr. Cecil. Yeah, that is. Thank you, Ron.
Your Honor, this court is allowed to take into consideration other facts that were presented. There was a trial, there was a preliminary examination. This defendant admitted during the plea process that he told his co-defendants to get a gun and kill that motherfucker. There was evidence presented, again, at the preliminary examination and at the trial. Every single person who was a member of this gang testified that Andrew Cecil was also a member of the Latin Counts. He has numerous Latin Count tattoos. So he has the Amor, the Fear None, Boss Time, Southwest. I would ask the court to amend page 19 to include that he is a member of the Latin Counts, and under gang marks, scars, and tattoos to add those tattoos, Your Honor.
May I respond to that, Your Honor? And I'll be brief because I didn't try the initial case, but I had the opportunity to read on 2,020 pages. And there were a number of persons, Your Honor, who testified who were no longer gang members, who still had their tattoos simply because they couldn't afford to get rid of them. So respectfully, without further information, further testimony, further evidence, the presence of the tattoos by themselves without supportive documentation. In this case, the Chief, Your Honor, I think that it is a consideration that the court, I would pray, would not take into consideration at work. Thank you, Judge.
Mr. Lyons, can you clarify for me which member of the Latin House testified that was no longer a member and couldn't afford to move to?
Like I said, this, Judge, there were a number of them who were no longer in this game, who did not have who still had their tattoos.
I believe that the court is permitted to engage in judicial fact finding with respect to the information that goes into the pre-sentence investigation report, and the standard for establishing those facts by a preponderance of evidence. I also think it's appropriate to look at the trial testimony in this case and other evidence that was submitted in this case. In order to do that, I think that there was ample evidence within testimony and evidence given in first trial to find that Mr. Cecil was a member of Land Counts. So I would modify page 19 under gang involvement to include a statement that Mr. Cecil is or was a member of the Land Count.
Those tattoos, can you say what those were again? There none?
Amor, AMOR. Fear none. Boss time, BOSSTIME. And Southwest.
Thank you.
All right, is there anything else, Ms. Wise?
No, Your Honor.
Mr. Lyons, pre-sentence report disclosing prior convictions in which there existing and known constitutional defects.
No, Your Honor, I'll address those issues.
The probation officer has computed the minimum sentencing guidelines in the case to be from 62 to 142 months. Do you agree with that computation, Mr. Lyons?
I concur.
Ms. Wise, do people agree with that computation of guidelines?
Yes, Your Honor.
Before the court passes sentence, then Mr. Lyons, is there anything you'd like to say on behalf of Mr. Cecil?
If I may briefly, Your Honor. This court having set the trial, probably we're intimately familiar with the facts, allegations, counsel is. And there is absolutely nothing I can offer that can soothe a mother's broken heart. I don't have, there may be balm and Gilead, but there's nothing that I can offer, Your Honor, other than say that my thoughts and my prayers sincerely are with the family of the young man I have lost. My client has taken responsibility for the part that he played in that. I won't insult the court's intelligence by saying that there's anything the court can do today that's going to put this thing right. But he's taken responsibility. He's showing you documentation today, and I did that, Your Honor, only to show the court that he's not just sitting on his butt waiting to get out to recommence a lifestyle that's inappropriate to what we think is a good life. He's taking advantage of that, sitting in school, attempting to learn something, earn a degree. He's address other issues so that he can do his time, won't do him. The only major issue that remains today is whether the court is going to make him sit on 2.5 years of dead time, or whether the court is going to give him credit for that. Your Honor, will another 2 years of punishment, would that add to the sugar to the family? Or at some point, it's become more punitive than it is rehabilitative. It's moving forward in an attempt to rehabilitate. Respectfully, we're asking the court to exercise this discretion and giving him credit for that time served and not stack these things. Again, it's false, fully within the discretion of the honorable court. No argument with that. That is our prayer. Thank you.
Mr. Cecil, is there anything that you would like to say before the court passes sentence?
Yeah, Your Honor, I apologize.
Can I just ask you to move to the podium so that you're in front of a microphone that'll be closer to you?
I'd like to apologize to Mrs. Dickerson. I don't know what it's like losing a son. I can't imagine the pain you're going through. There's nothing I can say or do to make things right. All I can say is, I'm sorry, take responsibility, try to move forward with my life, try to better myself. And apologize to the court, everybody's time and energy wasted on this case. I know it's been a long road. Just trying to move forward and better my life. All I ask is be fair and just. Whatever that is, I'll accept. Thank you.
Ms. Wise, the people wish to hear.
Yes, Your Honor, maybe Tracy Dickerson addresses the court first.
Ms. Dickerson, if you'll just state your full name and then you can proceed with any statement you'd like.
Tracy Dickerson. Good morning, Your Honor. I don't want to stand up here and read another 6-page victim impact statement. This isn't our first rodeo. First and foremost, I would like to thank all the ones that helped bring justice for my son. The detectives, the prosecutors, and the victim rights advocates. They've spent thousands of hours on this case, Your Honor. And Your Honor, I want to thank you. Thank you for doing your job. Your Honor, this case started on May 1st, 2018, when this person stabbed and tried to kill my son the first time. Instead of taking responsibility for what he did, he decided it was better to have my son murdered, keep him from testifying at his trial. Your Honor, the sad part of that is my son wasn't going to testify at his trial. I know there's a lot that I need to say, but I am so mentally exhausted that I am finding it hard to find the words. I definitely do not think this person deserved this plea deal, but I was so tired to continue to fight. This case has consumed my life since May 1st, 2018. And my biggest regret is I have neglected my other sons and my grandchildren. I am looking forward to restarting my life. I want to make memories with my family again. I want to do Christmas again, decorating the tree at home, making cookies with the kids. Forward to the football games again at the house. I have held such hatred inside of me for the last 6 years. But Chris has let me know that enough is enough. He is at peace now. And it is time for me to let go of all the hatred and start living my life again. Now, I'm not saying that I still won't turn on YouTube to watch you on Wednesdays, because I enjoy that. But it will not consume my life anymore. So, Your Honor, I just want this person to know, even though I will miss my son dearly, my life will go on. My 3 boys and my grandchildren will get their mother and grandmother back. I know they have missed her, and I have missed her. But that stops today. Again, Your Honor, thank you for doing your job.
Ms. Weiss, do people have anything else?
Your Honor, this is the second separate sentencing we've been in front of this court for. First time, Mr. Cecil apologized to Ms. Dickerson. He was sorry for losing his cool and stabbing her son, all the while knowing he was dead, that he had him murdered so he couldn't come testify against him at a. And for what? He was offered a plea where he was going to be out. It was senseless. There was no point to this. And now Mr. Cecil is standing in front of this court the second time around, asking this court to be fair and just. And don't make him sit on dead time. Well, Your Honor, Chris Dickerson is on dead time. Chris Dickerson is not here today, and I would ask this court to be fair and just. I would ask this court to not give him credit for the time that he is serving on the underlying case.
There really is just the decision for the court to make, right, at this point in time. And the way we've gotten here has been a long, long road for everyone. And when this deal was struck, Ms. Dickerson and her family approved the resolution of the case in this manner. And the couple factors that I would like to point out to the court today, I think are relevant to the point of whether or not to give credit on this issue. And the first thing I remember, and I have some notes here, and from Ms. Dickerson, and when she spoke about this before, and she said these words at the hospital after Chris was stabbed. I asked him who stabbed him, and he said he could not tell me. I asked him why he could not tell me, and he said, "Mom, they will kill me." I said, "What do you mean?" I told him, "Chris, you cannot let somebody who tried to kill you get away with it." I told him, "What if they try it again and succeed?" He told me with tears in his eyes, "Mom, you just don't understand what they will do to me for telling." Chris Dickerson predicted his own death. He foreshadowed that with his mom. And it came true. Needlessly. Because as she spoke, and because it was so unnecessary to do this, there was nothing that was going to force him to testify. Eventually the case would have gone to trial, or they would have worked it out. And Chris would be alive, and they still would have used the transcript like they did at the trial after they determined that Chris had passed away, been killed, murdered. This is the stupidest murder that I can think that has occurred in Lenawee County over my career. So unnecessary. And yet, how do you make justice right here? How do you do something proportional? How do you do something for the standpoint of deterrence? Why would you give someone credit for a time period that they caused to occur? Mr. Cecil tried to kill Chris Dickerson once before. Did anyone really believe that he would fail the second time he tried? He made access villains that he had in his control disposal. Mr. Trevino, Mr. Richardson, Mr. Taylor. Your Honor, it is fair, it is just to not allow him credit for those 783 days, because that's all we're really arguing about today. Tracy Dickerson will never forget Chris Dickerson. I'm very hopeful. I don't think anybody in this courtroom will. I'm very hopeful that what the court does today will make it so Andrew Cecil never forgets Chris Dickerson. Because make no mistake, it was Andrew Cecil who lit the fuse that resulted in a chain reaction whereby 3 bullets exploded into Chris Dickerson's brain. Thank you.
In determining the appropriate sentence in the case, the court considered the seriousness of the offense, their history, the principle of proportionality, statutory penalty, cost of confinement, report, and recommendation of the probation department, as well as what's been said on the record here today. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, vindication for the law, and the protection of society. Mr. Cecil has been convicted now of manslaughter and felony firearm offense, or to resolve a case that charged murder, conspiracy to commit murder, solicitation of murder, as well as some other charges. These are the 5th and 6th felony convictions at the age of 33. Mr. Cecil has been serving a prison sentence since February of 2020 as a result of the assault with intent to do great bodily harm conviction involving Christopher Dickerson. Do recognize that he has provided evidence that he's taken some classes at Jackson College and an anger management class. I would also note that the pre-sentence investigation report includes information about misconducts during his time in prison that include 3 for substance abuse, possession of stolen property or theft, interference with administration of rules. There were 3 of those as well. Possession of dangerous contraband, destruction or misuse of property, and fighting. It's also significant to the court that these offenses were committed for the purpose of subverting the justice system. Mr. Cecil was pending trial for the assault with intent to do great bodily harm, less than murder charge, when all of this occurred and when the murder of Christopher Dickerson was directed in an effort to meet the first charge. And so get to the other impacts in a moment, and all crimes are brought by the people because they affect or harm the people of the state of Michigan. So that is the plaintiff in these cases. But in this case, it's particularly true where we have a justice system that is designed to try to find the truth when charges are made. And in this case, Christopher Dickerson was murdered in an attempt to hide that truth. It also had a devastating impact on Mrs. Dickerson and her family. The court has now heard about that impact several times, and there is no way that we can make right the wrong that has occurred. There is no way that we can craft a sentence that will allow Mrs. Dickerson and her family to experience the joys of life that they would have if they had their son and their brother. So the sentence in this case was, other than the issue of discretionary consecutive sentence with respect to the felony firearm being consecutive to the assault with intent to do great bodily harm sentence, has been agreed to. And that sentence is 2 years for the felony firearm. That is statutory required. And there's a plea agreement for a sentence on the manslaughter charge to 10 to 22.5 years. So it will be the sentence of the court that you serve 2 years with respect to the felony firearm. And I acknowledge that the decision on whether to make that consecutive to the assault with intent to do great bodily harm less than murder sentence is discretionary for the court. And I do believe in this case that it is appropriate to make that a consecutive sentence to the assault charge, or the sentence being served as a result of the assault conviction. And the reason for that is, first, that both offenses involved the same victim, Christopher Dickerson. As I discussed earlier, the second offense was committed for the purpose of preventing him from testifying at the first trial. And so in my opinion, I do not call the first sentence that you are serving dead time, as it's commonly known. I think quite the opposite is true. I think that if I were to make those concurrent sentences, that we would more or less erase or limit the fact that a second offense occurred. I think the reason, as I stated earlier, a second reason for the consecutive sentence is, again, the damage that you attempted to do to the justice system itself. And this is a crime that was committed for the purpose of preventing someone from testifying at the trial for the first offense. And I think finally, the factors that weigh heaviest in making my decision about a sentence in this case are the protection of society and deterrence against repetition that I mentioned earlier. And I think that both of those factors would be seriously undermined by concurrent sentences in the context of this case. So again, it will be the sentence of the court that with respect to count 2, the felony firearm, that Mr. Cecil served 2 years, the Michigan Department of Corrections, that is consecutive to the current sentence for assault with intent to do great bodily harm less than murder. With respect to count 1, again, the agreed upon sentence is 10 to 22.5 years, and that is mandatory, required to be consecutive to the felony firearm charge. pursuant to MCL 750.277B. There is also restitution in the amount of $6,039. $1,039 paid to Tracina Dickerson and $5,000 to Crime Victims Compensation. You must also pay a $130 state cost and $68. I'm sorry, $130 crime victims rights fee and a $68 state cost for each felony.
So that's 136 for state costs.
You must not have verbal, written, electronic, or physical contact with the family of Christopher Dickerson, either directly or through another person. Not have verbal, written, electronic, or physical contact with anyone that you know to be a member of a gang, and you must not be involved in any gang-related activities. You must not have verbal, written, electronic, or physical contact with anyone. That you know to be engaged in any behavior that constitutes a violation of any criminal law of any government. You must not own or possess a firearm or any type of, including any imitation or simulation of a firearm. You must not be in the company of anyone you know to possess those items. Do have Mr. Cecil the ability to request an appeal of your sentence. The bailiff is going to hand to you 3 copies of notice of right to appellate review and request for appointment of attorney form. You sign 1 copy of that form, which indicates that you received the forms. If you want to appeal your sentence, you need to fill out the other portion of the form and mail it to the address listed in the form within 42 days.
But my client acknowledges receipt of his appellate, notice of appellate rights. He is signing the copy or receipt for the court.
Thank you. And just for clarification of the record, based on the consecutive nature of the sentencing, there will be no credit for time served on either of the.
Your Honor.
Ron, thank you.
Thank you, Your Honor.